parent leave. This is a job-protected leave. It's mostly a reminder because we're finding that a lot of folks are not quite understanding this. We've all heard about the California Family Rights Act, Family Medical Leave Act. If you have 50 or more employees, you have to give people time off for not only their own medical condition, but the medical condition of their parents, children, spouse, and also they get to take time off to bond with a new baby. Those are all separate things. And if you have fewer than 50 employees, you weren't required to worry about any of this, although in California, pregnancy disability leave is an additional entitlement. And we always were trying to let people understand, have people understand that pregnancy disability leave is separate from bonding with baby. Well, the California legislature has focused in on that point too, and they have added a statute that says, well, if you have 20 or more, they've dropped this number down to 20, you have to give people time off to bond with baby. So while pregnancy disability leave applies to 5 or more, this is if you have 20 or more, separate from pregnancy disability time off. They have an entitlement to time off, and it's job-protected leave to bond with a new baby. And one of the things I mentioned, or new foster child, new adopted child. That's also included. I call it the new kid. And just so you know, a kid is new for 12 months. After that, it's the old kid. Nothing new to see here, folks. Move along, get to work. So I encourage you to take a look at this. If you have 20 or more employees, this is going to apply to you. Going to skip over to page 28 on item 48. I'd like to mention paid family leave. This is a benefit that's administered by the EDD. Make sure you understand that this is not something where you have to add it to your payroll. You're all familiar with SDI. Somebody goes out for a health condition, they will apply to the EDD, and maybe they get state disability insurance benefits. This is the same kind of thing, but for other stuff. This is if somebody does get, if you grant somebody a leave of absence to care for a sick child, parent, or spouse, or bond with baby, even if you've only got one employee, you've been having payroll deductions taken out of that person's paycheck for them to go to the EDD and apply for some benefits while they're out for that purpose. So it's not a leave entitlement on its own, but again, there's some movement by plaintiffs' attorneys to say, hey, well, if you do grant somebody this leave, or you should, it's sort of a matter of public policy, but if you don't, are you in trouble? You shouldn't be. But a lot of folks are trying to say, well, certainly if you do give somebody that time off, you'd better return them from that leave, because granting a leave of absence sort of assumes that you're telling them they're going to be able to come back. If you do grant somebody the time off for one of these purposes, can you require them to use any of their PTO? The statute says that you can require them to use up to 2 weeks of their vacation. Now keep in mind, if you do that, the paid family leave benefit is 6 weeks worth of time that they can collect a certain percentage of their salary, their wages, for 6 weeks during that time off. That's the amount of that leave. If you say, well, you're going to have to use vacation for for 2 weeks before you get that leave, you're kind of telling them they have 8 weeks. There's also no longer the waiting time period before they can collect those benefits. So if you're not giving them any paid time off before they collect or apply to that, they don't have to wait. The first 7 days are unpaid. They can get that from day 1 of the leave. But if you're paying for their time through vacation usage, then they would get the paid family leave insurance benefits from the EDD once that pay stops. You can also coordinate those benefits. There's actually a little bit of information in here on the practice tip on item 49 that directly addresses what you're talking about.